I am surprised to see allegations that the state did not turn over evidence. We're going to evaluate that today. Kouri Richins is accused of poisoning her husband with fentanyl when she was in the middle of significant financial trouble, like girl boss too close to the sun. This was originally set for trial, and then it got continued for a ton of motions and an appeal to the state Supreme Court. They were trying to bring in a bigger jury veneer. They were trying to change venue. Much happened. It was all denied. We're back in front of Judge M and his fabulous beard and his deep, spicy novel-esque voice. I'm sure he's thrilled with us for that. This is also the case where Brad Bloodworth, the prosecutor, was talking about docket 214, because docket 214 is the walk the dog letter. And in court, they've talked about this channel a few times, not by name, but in court, the prosecutor said, you might remember this.
But every law nerd on the internet calls it the walk the dog letter.
Look, Judge M, we love you. The law nerds don't fuck around. The law nerds are not the side of the internet you're looking for when you're annoyed with the internet. It's not the law nerds. We're not the problem. And now that the defense is saying that maybe the prosecution is withholding evidence, we really want to know what's happening. We want to make sure that prosecutors are doing what they're supposed to be doing. We want to see good lawyers do good lawyer work. For those of you that have been following this case with me, and that's about 80% of you, a lot of you haven't heard of this case before, Google will get you is like not legal advice, just practical advice. Google will get you, because the Googling in this case is wild. We'll hear about it in the fourth indictment in this case. This is the fourth indictment in the murder case. We have also covered the indictment in the separate fraud case that was filed later. That fraud case involves the mortgage fraud, the forgery, the life insurance fraud, and the rest of it. Then there is the criminal murder case, and then there is the criminal fraud case. The prosecutors have separated things out. The judge separated part of that out. So we're not going to get like a murder fraud within a murder trial. Let's take a look at the prosecution's fourth amended information, shall we? We know what the charges are in this case. I'm not going to read them in full. Charge 1 is the aggravated murder, criminal homicide on or about March 3rd and 4th, because it was in the overnight hour. The attempted murder, which is from February 14th, there's an accusation that Kouri Richins attempted to poison Eric Richins before, and then there is additional information on that. So defendant told law enforcement while EMS was still working on Eric Richins at the home that Eric Richins and she had a drink together at 9 o'clock to celebrate something at work tomorrow. A year later, defendant told law enforcement, I made Moscow mules in the kitchen, and then I brought them into our bedroom. Defendant further said that they drank the Moscow mules sitting on the bed. Sometime after Eric Richins' death, defendant wrote in a journal. This journal is still the subject to some motions to exclude about whether or not it was properly seized. So there is some question about whether the journal will come in. And we have been waiting to find out what's in the journal because we've heard about the journal. They've talked about the journal. We have heard reference to the journal, but we have not gotten into what was in the fucking journal. Defendant wrote in the journal the night of Eric Richins' death that she and Eric Richins went to the kitchen and both started grabbing ingredients for a Moscow mule and a lemon drop. We finished talking, made our way back to our bedroom, and brushed our teeth. Valentine's Day 2022. At 1:59 p.m., Eric Richins called witness 1, a close friend, and reported, "You almost lost me." Eric Richins told witness 1 that the defendant had left him a sandwich and a note in the front seat of his truck, and he went in the house with the sandwich, had one bite of the sandwich, and broke out into hives. Eric Richins said that he injected himself with his son's EpiPen that was on the counter, drank a bottle of Benadryl, and went to sleep. Eric Richins told witness 1 that he had almost died. Witness 1 could hear the fear in Eric Richins' voice and tell that Eric was scared. This is going to come into trial as a present sense impression from Eric Richins' to friend. At 2:11 p.m., Eric Richins called witness 2, another close friend, and reported, "I think my wife tried to poison me." Eric Richins told witness 2 that the defendant had left him his favorite sandwich from the diner along with a note. He said that he ate some of the sandwich, got sick, and blacked out. He told witness 2 that he felt like he was going to die. Witness 2 was struck by the tone of Eric Richins' voice and said Eric Richins seemed a bit different, down, and somber. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions, to include hives. Eric Richins did not have any food allergies. This next part is going to be part of the motions that we're going to cover today. Defendant purchased illicit fentanyl shortly before Eric Richins' near death on Valentine's Day 2022 and death on March 3rd and 4th, 2022. The defendant occasionally employed witness 3 to assist her with renovating houses. On January 20th, 2022, defendant text message witness 3, quote, "I did want to chat with you about something super random, exclamation point. Not now at kid stuff, exclamation point. I'll call you tomorrow if that works." So she text message somebody, "I want to talk to you, but not now." On January 21st, 2022 at 7:24 p.m., the defendant text message witness 3, "Hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd at 11:06 a.m., the defendant text message witness 3, "Got a sec?" Witness 3 told law enforcement that he spoke with the defendant on January 22nd, 2022, and the defendant asked him for fentanyl. The defendant told witness 3 she wanted fentanyl, quote, "for a client who had back pain." Ma'am, you're a realtor that flips houses. What other services are you telling people you're providing? Witness 3 told the defendant that he would not get her fentanyl. The defendant hung up on witness 3. On January 22nd, 2022 at 5:35 p.m., after the phone call in which witness 3 declined to acquiesce to defendant's request, the defendant text messaged witness 3, "Have another one for you. Call me if you get a sec." Witness 3 told law enforcement that during the second phone call with the defendant asked him for propofol. Witness 3 told the defendant he could not get her propofol. The text messages from January 22nd, 2022 between defendant and witness 3 were manually deleted from the defendant's phone. They got them from the other person's phone. After that date, the defendant and witness 3 did not communicate ever again. The defendant and witness 3 had communicated regularly throughout the prior year. On May 31st, 2022, approximately 3 weeks after defendant's arrest for the murder of Eric Richins, the defendant's mother text messaged the defendant, quote, "witness 3 name, running his mouth." The defendant occasionally employed witness 4 to clean houses. Witness 4 told law enforcement that sometime in early 2022, before Eric's death, the defendant either called or texted and asked her to procure some fentanyl for defendant. Forensic analysis of Verizon records for defendant's cell phone shows 746 SMS text messages, 94 MMS messages, and 12 calls between defendant's phone and witness 4's phone between January 1, 2022 and March 15th, 2022. These messages were manually deleted from defendant's phone. The defendant's phone contained messages to and from witness 4 before and after this time frame. To forensic examiners, a big glaring gap is just as telling. Witness 4 told law enforcement that pursuant to defendant's request, she contacted witness 5 for an introduction to someone that would sell her fentanyl. Witness 5 confirmed that witness 4 asked her for the introduction to someone that would sell. Witness 5 elaborated that witness 4 messaged her through Facebook asking to speak with her and called witness 4 shortly thereafter. Facebook message from witness 4 to witness 5 on February 5th, 2022 at 1:37 asked, "Text me, I got a question, won't do it on this." In response to witness 4's inquiry, witness 5 provided witness 4 with the phone number of a dealer, witness 6. This is going to come up as we continue on into these filings. Witness 4's phone contains a contact for witness 6 with their phone number. The contact is labeled in a fashion that connects witness 5 with witness 6. Witness 4 told law enforcement she contacted witness 6 shortly after receiving the contact information from witness 5 and asked to make the purchase. Witness 4's phone records established she texted witness 6 on February 10th at 8:52 p.m. Witness 4 told law enforcement that she met witness 6 at the Maverick gas station in Draper on February 11th and purchased from him 15 to 30 round light green blue pills, which she understood to be fentanyl. Witness 4 told law enforcement that she delivered the pills that she purchased from witness 6 to the defendant in a hand-to-hand transaction in the driveway of her home on February 11th or February 12th. Witness 4's phone data shows that in the addition to the text between the defendant and her that were exchanged on February 11th, the defendant and the witness exchanged text messages on the 12th at 9:58 a.m. and 2:49 p.m. Witness 4 was located at her home during the exchanges. The defendant and witness 4 exchanged 30 text messages on Valentine's Day 2022. Remember, Valentine's Day is when Eric took a bite of the breakfast sandwich and broke out into hives. Witness 4 told law enforcement that in late February, the defendant told her that the fentanyl pills she previously provided were not strong enough and asked that she procure some stronger fentanyl. Internet searches on defendant's phone. The defendant uses several cell phones, including burners. The cell phones that the defendant primarily used leading up to and shortly after Richins' death, Eric's death, indicates that a significant amount of information was manually deleted from it, particularly between January and mid-March of 2022. Forensic analysis of one of defendant's cell phones shows that by April 16th, 2022, 3 days after law enforcement first informed the defendant that Eric Richins died of a fentanyl overdose, the defendant's cell phone was used to access website articles with the following titles, among others. So these are articles, not Google searches. We'll get there. Utah State Prison, Timpango's women's facility. What happens to deleted messages? Cause of death does not impact life insurance payment. How do police and forensic analysts recover deleted data from phones? And signs of being under federal investigation. Forensic analysis of the same phone also shows that by June 6, 2022, the defendant's phone was used to conduct the following internet searches, among others. Quote, can you delete everything off an old iPhone without actually having it? Quote, women Utah prison. Quote, can cops uncover deleted messages iPhone? Quote, can cops force you to do a lie detector test? Quote, if someone is poisoned, what does it go down on death certificate as? Quote, how long, she actually typed HOW, how long does life insurance companies take to pay? And quote, what is a lethal dose of fentanyl? Including the periods that happen so often in iPhone searches instead of hitting the space button. Why they didn't include the Google search for luxury prisons for rich people, I don't know. It's included in others. It's not included in this one. Defendant fraudulently claimed insurance benefits from Eric's death. One of the policies issued on May 12, 2017, the other February 4th, 2022, 1 month prior to his death. On April 28, 2022, defendant submitted a claim against the policies. On June 7th, True Stage learned that the cause of death, so not until June are they starting to learn about the cause of death. On June 7th, True Stage learned that the cause of death was drug intoxication fentanyl. On June 14th, True Stage left a voicemail with Kouri requesting a copy of the prescription for the fentanyl. Later the same day, defendant informed True Stage that the fentanyl was not prescribed and that she didn't have any idea how he obtained it. The next day, on June 15th, the defendant reiterated to True Stage that she really did not know where Eric obtained it. That is the end of the updated information that they're going to go to trial on. This was filed just last week. This is the defense request for an order compelling disclosure of exculpatory evidence. So we are going to go through what the defense is arguing, what they are asking the court to compel, and what they are asking the court to turn over. Quote, prosecutors say she mixed a lethal dose of fentanyl into his drink, footnote 1 from the New York Times. Kouri Richins' housekeeper allegedly sold her fentanyl pills prior to husband's poisoning. Footnote 2, link to YouTube video. Kouri Richins, the Utah mom who allegedly poisoned her husband with fentanyl-laced cocktail. Footnote 3. And every time they say fentanyl, it is italicized. The defense then says, all those headlines stem from allegations that Miss Richins procured oxycodone and ultimately fentanyl from her relationships and connections with, well, they're just putting everybody's names out here now. CL is the go-between who did the hand-to-hand transaction and was finding everybody else. That's who CL is. Robert Crozier, Nick Bonsavage, and Susan Kohler. Initially, Miss Luber, CL, informed investigators that fentanyl was never procured. See transcript of the interview, April 27, 2023. The investigating officers subsequently interviewed her on May 3rd, 2023. It was in that meeting that she indicated she got fentanyl from Robert Crozier. That is alleged to be the individual that was at the Maverick gas station giving the narcotics to CL, who took them back to Kouri. Robbie was interviewed in May 2023. During his interview, he confirmed that he had sold fentanyl to CL on 2 occasions. Remember, there is the before Valentine's Day and then there's the after Valentine's Day. Before Valentine's Day, the egg sandwich made Eric Richins incredibly sick. After Valentine's Day in March, it was alleged to be a Moscow Mule, and that is when he was deceased and had a significant amount of fentanyl in his system. Sometime in April of this year, Crozier was interviewed by 2 members of Summit County prosecution team at Starbucks in Salt Lake City. The prosecution team asked if he had sold fentanyl to Ms. Luber. He said he had not sold fentanyl. He specified that he had sold Oxycodone to Ms. Luber on 2 occasions in early 2022. He told the prosecution team that he met with CL at the Maverick in Draper both times to sell her pills. The prosecution team asked why he had stated that he had sold fentanyl. He specified that he did not remember saying that he had sold fentanyl and told them he had been detoxing during that interview and was quote unquote out of it. He told the prosecution team that he was certain he had sold her Oxycontin 30 milligram pills, also known as Roxy's. The prosecution team asked him several times if he was sure, and he told them he was sure it was Oxycontin. The prosecution has been aware of this exculpatory evidence since April of this year. The prosecution did not inform the defense of this information. I'm very curious how the prosecution is going to respond to this. I mean, it was ultimately fentanyl in his system. So whatever he thought he was selling, it was ultimately fentanyl in Eric's system on the 3rd. Could oxycodone cause that type of reaction with the breaking out in hives from Valentine's Day? They said it can in their information. So I don't know if it's exculpatory or not, but any change of witness statement has to be turned over. They say that the prosecution knew this since April of this year and did not inform the defense. That's a problem. What's the solution to that problem? Well, they haven't gone to trial yet. The solution is normally, well, you have the information now and you can ask the witness about it. But they are then complaining that there's no press release issued, no reports, nothing. The prosecution just kept quiet. They needed to turn it over to the defense. In preparation for trial, defense counsel located and interviewed the witness within the past 30 days. Well, yeah, he's on the witness list. It was during this interview that the meeting and the exculpatory information became known to defense counsel. They're calling the difference between whether he sold fentanyl or whether he sold oxy to be the exculpatory thing. We can argue over and over about whether or not that's exculpatory. It doesn't matter. It needs to be turned over. Here, the prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. The prosecution's failure to disclose and continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl inflicts ongoing harm on Ms. Richins, the public, and the integrity of our legal system. They are banging the podium with this and doing their job. But Ms. Richins intended to procure fentanyl. Eric Richins, at his autopsy, in his system, had fentanyl. So if a witness comes in now and says, I originally said I sold fentanyl, but I was selling oxycodone, the jury's going to be like, A, are you distancing yourself? Or B, did you think it was oxycodone and it was so laced with fentanyl that fentanyl's all that showed up in his system? Or is it something else? Counsel moves this court for a standing order imposing a 3-day deadline on the prosecution to disclose the following to the defense. The court has not, by the way, issued an order on this. They are asking the court for a 3-day deadline. All evidence, including emails, text messages, phone messages, recording, video footage, and any other form of correspondence involving the prosecution teams or any law enforcement official and the witness. Okay, fair. All notes, correspondence, reports prepared by law enforcement officials or any member of the prosecution team discussing the interview in April. Conversations between the attorneys is going to be work product. Same with law enforcement. A summary of the meeting is probably appropriate. Any statements, recordings, reports, or notes in whatever medium, including emails and texts, that tend to negate guilt. I mean, I think their argument of what negates guilt and the prosecution's view of what negates guilt are going to be different. Furthermore, the defense respectfully requests the court require the prosecution to disclose on the record or reduce to writing and provide to the defense all oral statements discovered when interviewing witnesses that tend to negate guilt or contradict prior statements by witnesses. Yes, that should happen. My name is Robert Crozier. I'm residing in Davis County Jail. I'm over 18. In early 2022, I was contacted by my friend Nicole Cummings, telling me that a friend of hers by the name Carmen was looking for some pills and would be contacting me. In May of 2023, I was arrested for, it says selling fentanyl, but then it said possessing fentanyl. It was changed, and was in Davis County Jail. At that time, 2 officers from Summit County Police Department interviewed me. I do not remember their names. I was very confused during the interview as I was detoxing from drug use and was very out of it. That is entirely possible. That is why they should record these and video record them. At first, I did not remember Carmen, but after they reminded me, I did remember that I had sold pills to her and that she was a friend of Nicole Cummings. I don't remember the details of the interview, but I have since been told that during the interview, I agreed that I had sold fentanyl to Carmen and that blues refer to fentanyl. It is my belief that I agreed I had sold Carmen Luber fentanyl because I was personally detoxing from fentanyl during that interview, and by then had been selling fentanyl, which I had come to know as blues. It's completely plausible. He goes on to say, I did not sell Carmen fentanyl in February 2022, but sold her 30 milligram Oxycodone pills. In early 2022, I was not selling fentanyl and did not have access to fentanyl. Rather, I was selling my own Oxycodone prescription, which were 10 milligram pills. If a buyer wanted stronger pills, I had a source who provided 30 milligram Oxycodone, which is what I sold. But do you know where they got them from? And do you know what was in them? No. And that is one of the things that is so scary. You do not know. He goes on to say Roxy's or Roxy 30s refers to 30 milligram Oxycontin pills. To my knowledge, blues also refer to Oxycontin until late 2022 when I came to know the term as also being used for fentanyl. I did not acquire a source of fentanyl until the end of 2022. The fentanyl pills that I began selling at that time were very dark blue, almost purple. In April of 2025, I was interviewed by prosecutors with Summit County Attorney's Office and told them I had sold Oxycontin to Carmen and not fentanyl. I certify that this is true. Okay. So I am curious to know when the second interview got turned over. Where are we at the end of the day with the Kouri Richins case? The defense is asking for bail. The defense is asking that the court force the prosecution to turn over, witness statements, which they should be doing anyway. The defense has posed that there was an updated witness interview in April 2025 that was not disclosed to them, and they did not discover that the witness had been interviewed until they went and interviewed that witness in September because that witness is on the state's witness list. The defense says that the witness recanted their statement. The defense used a lot of hyperbole in their argument, but the changed statement is that the go-between from Kouri Richins to a dealer went to the dealer and procured pills of Oxycontin and not pills of fentanyl. That is what the dealer is now saying, and saying that in their original interview, they said they sold fentanyl, but at the time they were in custody and were detoxing from their own fentanyl use and were, in their words, out of it during that interview. But that is also a recorded interview, so the jury will get to decide for themselves. They also said that in early 2022, they referred to Oxy as blues, and in late 2022, they referred to fentanyl as blues, and that at least one point, Carmen had asked for blues and at one point had asked for Oxycontin. What we know about Kouri's case in this part is that before the attempted murder charge from Valentine's Day, Kouri had reached out to 2 individuals, Carmen and another individual, asking for pills and saying that she needed them for a client for back pain. And that the first person was like, no, click, and they never spoke again. The second person, Carmen, reached out to a friend who put her in contact with a friend who met her at the Maverick and Draper and sold her pills. And those pills she gave to Kouri. And then on Valentine's Day, Eric Richins got so sick that he told his friends that he almost died, broke out in hives when he reached out to Kouri and said, I think I might have to go to the hospital, but I think I'm going to take a nap. She said, yeah, take a nap and let me know. And then after that, Kouri reached back out to Carmen and said, I'm going to need something stronger. And then Carmen reached back out to the dealer and said, I'm going to need something else. And then the dealer gave pills to Carmen that they are now saying was oxy and not fentanyl. Those went to Carmen. Those then went to Kouri, and Eric Richins died of a fentanyl overdose on March 3rd. So if the dealer who is giving pills to Carmen says that those pills weren't fentanyl and they were oxy, is that exculpatory? I don't necessarily think a jury will see it that way. I don't think it undermines the case based on Kouri Richins' own statements and requests. And it will be interesting how that comes out in evidence, because at the end of the day, the witness said, I sold pills, but they were this type of pill, not that type of pill. It will be interesting if the prosecution adds a law enforcement witness to explain how things on the street are laced. We'll see. But I'm most curious about the change of statement not being turned over to the defense. When that statement was changed in April of 2025, it should have been turned over to the defense. What are the potential outcomes from that? Well, it's known now. The defense went and interviewed the witness who's on the witness list, so they are aware. So we'll see what the court has to say about that. The prosecution hasn't responded to these allegations, hasn't responded to the defense's allegations that a critical witness in this case has recanted. I don't see it that way when we look at the facts. And in fact, this witness said in their statement, at the time I was selling my own prescription pills, but if somebody wanted something stronger, I had a guy that I could go get 30 milligram pills from, and that's what I did to give to Carmen the second time. So the Kouri asking for something stronger, Carmen asking for something stronger, Carmen asking the witness for something stronger, the witness procuring something stronger, giving it to Carmen, who gave it to Kouri, who gave it to Eric as alleged in this case, all lines up. The only one thing is different is that that individual is saying it was a different kind of opioid. I don't see that as recanting. The defense very much wants to make that happen, and in fact said that this was such a substantial change in the weight of the evidence that Kouri Richins should be let out on bail. I don't think the court's going to see it that way, and I think this has opened the door for the prosecutor, Brad Bloodworth, who really doesn't pass up an opportunity to lay out the facts of a case. I think this opens up the door for Brad Bloodworth to again lay out all of the evidence against Kouri Richins, which we reviewed in substance in the updated fourth information, which included new information from Kouri Richins' journal. And we took a look at that updated information in the updated probable cause statement on the fourth amended information, which is the one they're going to be going to trial on. It cleans up the charges. Remember, the prosecutors took out a number of the charges and put them into the financial prosecution. There is a separate financial prosecution in addition to the criminal homicide prosecution. So that fourth information is cleaned up with those charges, removes those charges, and the court had already separated some of those at the defense request, and the prosecution had already dropped two of the charges, which probably shouldn't have been filed in my opinion, but have been dropped. So the fourth information is cleaned up and does add new information. So is this a recanted statement? You're going to have to let me know what you think. Does this throw a grenade into the prosecution of Kouri Richins? Not even close. Is this a substantial change of circumstance that changes bail? No. Do I think the court will want to know why a witness statement from April wasn't turned over? Absolutely. The court's absolutely going to want to know that, and is going to say to the prosecution at some point, you need to make sure there's nothing else. This case is set to go to trial in February of 2026. We will see if the court allows it to be streamed in real time or on a delay or on a day's delay or whatever. But the court has allowed there to be some filming of the case. And so we are going to see what that looks like as we get closer to February. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.